we are going to learn law of contract in India. Law of contract in India is governed by the Indian Contract Act 1872. This comes under the ambit of mercantile law or business law. It came into force on 1st September 1872. It is a private law. Its base is in English common law, but it was passed in the Indian Parliament, which was in Calcutta. So this was the introduction about it, and something more we are going to learn in this introduction. Like, it contained 11 chapters, but Chapter 7, that was pertaining to sale of goods, and Chapter 11, that was pertaining to partnership, were repealed. And these sections, these were repealed. These chapters were repealed, but these chapters became independent acts after they got repealed from their parent act. And this parent act was Indian Contract Act, and they became separate acts as Sale of Goods Act 1930 and Indian Partnership Act 1932. So these became independent acts after that, and then they became distinct from Indian Contract Act 1872. So when we study law of contract, we must know its significance, why it is so significant. It is because all the commercial dealings are governed by this act, because it contains many things that we need to use in our daily lives while transacting businesses or commercial activities that we carry out. So it is so important. So as it covers like what is offer, because in order to create any agreement which will later become a contract, like any agreement which is enforceable by law will become a contract. And if it is not enforceable by law, it's merely an agreement, but you cannot get it enforced through any court of law. So it describes what is offer, acceptance, and what are the essentials of a contract, and what is valid consideration. Like, consideration is like what you give and what you take. So that is how an agreement comes into existence. Like, you agree to give something and take something, because if there is no consideration, if you are not giving anything or not taking anything in lieu of that, then it cannot form a valid agreement. And if it cannot form a valid agreement in itself by the definition in the English language, so it can never amount to a contract, because it does not fulfill the very basic definition of an agreement. And in order for a transaction to become a contract, first it should become an agreement. Then an agreement is a contract or not, that is a legal consideration, because if you can get it enforceable by law, then that agreement becomes a contract, and otherwise not. So this law of contract explains you all these things, like what is valid consideration, what are voidable agreements, what are void agreements, quasi contracts, damages under Indian Contract Act 1872, and apart from it, it also covers like indemnity, guarantee, bailment, pledge, and agency. Now we should understand what is contract, because we should have some basic idea before proceeding forward. Like if we need to study merely an introduction, so that we can have at least somewhat idea of this law of contract. So under the law of contract, or the Indian Contracts Act 1872, the contract finds its definition under section 2H, which states that an agreement that is enforceable by law is called contract. In contract, there must be an intent to create legal relationships, and not purely like social, moral, religious. Like you may have an agreement with your son that okay, if you get 85% marks in these examinations, I will get you a motorbike. So this is also an agreement, but it cannot become a contract. So it's merely an agreement between father and son. So this all is defined in the law of contract. If you understand the law of contract, you will be able to understand what sort of agreement can become a contract, and what is purely agreement, and it cannot amount to what is defined in the term contract according to law. Okay, so this was introduction about the law of contract, and now we will study all these things in detail so that we can have a proper idea of it and later on we will be able to draft proper contracts, and we will be able to draft agreements that will amount to contract, and we will be able to use proper legal verbatim, so that when we need to present those contracts in the court of law, they are valid and proper, and the court can understand them once court refers to them, and you will be able to present yourself in a better way if you have drafted a contract or a contract draft properly. So you will draft an agreement. So when we talk of contract, we draft an agreement. So when we draft an agreement, the same agreement becomes a contract if it is validated by the court, or it is valid. We deem it as a contract already, of course, but later on court may say it's not valid, so it will merely be an agreement. But in our eyes, or in our understanding, we create an agreement and call it a contract. And of course it's a contract because we have to have that sense that it is a valid contract, because if we do not consider it as a contract, then later on nobody else will. So that is the sense, and that is the essence. So this way we need to understand agreement and contract. So we will continue with the next chapter, that will be essentials of a contract, or essential elements of a contract.